One thing I always remind my clients when it comes to a general estate planning questions is you have to realize that estate planning documents go beyond merely who gets your stuff when you pass away. When people come to me for estate plan, they're mostly concerned about, I want some form of orderly distribution of my assets for the benefit of my spouse or my kids, or maybe a charitable consideration, or they want to know who's going to get my kids as far as guardianship if I pass away. But they're always forgetting a very important part of a comprehensive estate planning is that who takes care of you if you're unable to take care of yourself. And this is what we call documents of substituted judgment. Somebody is substituting their judgment for you because you're unable to make decisions for yourself. And these fall into two broad categories. One is a durable power of attorney for financial management, as well as what here in California we refer to as an advanced healthcare directive. Other states refer to it as a durable power of attorney for healthcare. So the first thing I want to point out to you that there's a difference between a power of attorney and a durable power of attorney. A regular power of attorney is when you simply designate somebody, typically it's an agent, to make decisions for you. It's just a power of attorney. You're giving them authority over medical, financial, purchasing a property, entering into a transaction to buy a house, or buy a car, whatever, power of attorney. And that power of attorney typically either has a natural expiration date because you put a date in there, or general powers of attorney will naturally terminate when the principal, the person giving the power, becomes incapacitated or dies. Well, a durable power of attorney then continues past the principal's incapacity. The whole point of these types of documents is so somebody could make decisions for you when you are in a state of incapacity. So you wouldn't want a normal power of attorney, you want a durable power of attorney. Okay, now that we got some of that semantics behind us. So in the financial realm, it's very important because you have things like who makes financial decisions for you. And it kind of cross-pollinates over in the medical side because in the advanced healthcare directive, you're designating someone to make medical decisions for you, someone to pick a quality of a long-term care facility for you. But now the question is, how do you pay for it? You can tell someone that you want to have a wonderful place to have independence and most home-like setting and social interactions and most home-like setting, but you need to have funds to pay for it. So over in the power of attorney for property management, that's where the source of funds may be. Someone may have to get access to your bank accounts. Somebody may have to sell one of your properties. Somebody may have to refinance one of your properties. What about dealing with life insurance policies and cash values and the investment portfolios? What about the real estate, retirement assets, being able to get access to retirement funds under these emergency circumstances? Claims and litigation, being able to sue someone that puts you in that incapacitated state. What about collecting government benefits? Very, very important powers are in the powers of attorney for property management. Now, when it also comes to my business owners, we have other things like business, who votes the stock, which comes up another very important point. I've mentioned in a previous video about the very important use of buy-sell agreements among business owners. But here, it cross-pollinates into a power of attorney, durable power of attorney for property management, because one of the general powers includes the power to exercise stock, vote the stock, sell stock, liquidate stock, LLCs, membership interest, partnership interest, et cetera, et cetera. So if you have a business partner that has a power of attorney and they become incapacitated and they're married, for example, the spouse most likely is going to be the agent exercising all the powers over a power of attorney. So although you and your business partner may get along just fine, you may not get along so well with the business partner's spouse. But if your business partner becomes incapacitated, who do you think is going to be exercising the stock? Again, but for a buy-sell. A buy-sell agreement intervenes here and prevents that from happening because the buy-sell automatically puts that stock over into the hands of the non-incapacitated business owner. So a very important thing when it comes over to business owners to have either a buy-sell agreement or a limited power of attorney. You may want to designate your spouse for everything for finances, bank accounts, retirements, 529 plan, digital assets, litigation, spouse. But the business may be a limited. Maybe your partner would be the agent under a limited durable power for business properties, or your CFO or your COO may want to be the agent only over the stock Therefore, you don't have to worry about the spouse intervening in business activity that they may not be too familiar with. But I'm recording this video because a very interesting question came up yesterday. And one of the powers is that they were trying to make changes to their trust when one spouse was alive and one spouse became incapacitated. And they had a general, in this case, a California general statutory form. It was kind of like a 2-page form, and they checked the box saying, I checked number 15, which means all the items were included, which basically just kind of absorbs all the things inside the probate code, all the general powers. And they tried to use that statutory form saying all powers as a way to allow the spouse, the non-incapacitated spouse, to be able to sign a trust amendment that affects both of their assets on their joint trust. And the problem is you can't do that. There is the general powers that they signed on that power of attorney form specifically excludes the power to create, modify, or revoke trusts, unless the trust says it's okay and or unless the power of attorney expressly allows that power. So one of the big downsides I see with people who have these statutory off-the-shelf type of powers of attorney is they don't understand fully the limitations on that. So here we had a situation where a spouse wanted to make a change to affect family members or successor trustees, and they were unable because they just had a standardized forms which did not go one step further and expressly allow the non-incapacitated spouse to make a change to the trust for both of their benefits. So that was a big problem. Another problem with those statutory forms is it doesn't have any limitation on who may be designated beneficiaries under very large assets such as retirement plans and insurance policies. So most Americans have 3 large assets, and you've heard me say this before in previous videos. It's their house, their insurance policy, and their retirement plan. And those statutory forms that you just signed, all powers, includes the power to allow the agent to designate a beneficiary of the insurance policy and the retirement plan. Why would you give someone that type of authority to be able to change the beneficiary of your retirement plan or your insurance policy to some third party? So here again, with a properly crafted power of attorney, a durable power of attorney for property management, one, you would allow for modifications, amendments, changes, revocations of trust where necessary and appropriate for the benefit of the incapacitated principal. And secondly, you definitely want to allow them to limit the power to make changes to the beneficiaries to either their spouse, their kids, maybe their grandkids, the trust that they formed, or maybe a charity. But you don't want to allow the power of attorney to designate some third party as a beneficiary of your insurance policy. That would be a bad idea. So if you have this general power of attorney, this durable power statutory form, you just signed, okay, all items below, thinking that you gave the broadest possible powers, first of all, you may have given too broad a power and then not broad enough in some circumstances. So in this case, give me a call. I'd love to review your powers of attorney. We can see whether there's rooms for improvement, whether you may want to have maybe a separate one, a limited versus a general. So give me a call. My name is Brad Barth. I'm a partner here at BarthCalderon, where we plan today for all of your tomorrows. Thanks for your attention. Bye-bye.